Good afternoon, everybody.
Yeah.
You guys ready to get started? Should I just like stand over here?
No, you're good. You should be
All
fine.
right.
I can move you there.
All right, cool. So my name is Justin Stivers. I see a lot of familiar faces. So I was here several months ago. Who was here last time when I did this probate course? Okay, you were there too, right? I've seen you. Okay, yeah. All right. So a couple of you all were here. So we'll try to do some new information as well. But thank you guys for having me again. Again, my name is Justin Stivers. I own what's called the Probate Law Firm. Based out of Brickell, we're operating in about 17 counties throughout the state of Florida. We do 100% probate. So I don't do closings, no real estate, no evictions, no family, none of that. Probate and only probate. So it's okay if you guys don't even know what probate is yet. I will explain that. But I've done this course a lot. I do. So if you're ever interested, I come to brokerages, but I also teach a longer course with the Miami Association of Realtors, and you can get 2 hours continuing education credit. So I do a couple of those every month or so. So if you're ever interested, just reach out, let me know. But I started doing this course because I kind of saw that probate is an area that a lot of realtors are coming, or a lot of realtors are finding, just by being South Florida, Florida in general, aging population. So chances are, probably at some point in your career, either on the listing or on the buyer side, you're probably going to come across something involving probate. So wherever. I know there are people trying to spread out. So, but this course, probably take 45 minutes or so, more or less, depending on how many questions that we have. But kind of 3 parts. I want to, teach you all how to identify when a property may need to go through probate. So when you're, again, working with a potential seller, potential buyer, you can kind of identify when the property needs to go through the probate process. How to explain the process a little bit to your clients, because, again, there's no secret, there's a ton of agents in South Florida. I think it's like 55,000, something, ridiculous. So just by knowing a little bit of the correct terminology, knowing how to explain the process to your clients will help you stand out from your competition. And then we'll talk a little bit about how to market for, how to find probate listings, and how to kind of maybe carve out a niche within the probate world. So that's a little bit of the course. What I always like to do, and since we kind of have a smallish group, again, thank you all for coming. Since we're being, since this is videotaped, whenever someone watches it, we're currently, zombie apocalypse right now. The world is ending, sort of thing. So thank you guys for coming. But what we'll do real quick is just, so I kind of have an idea, is we'll go around the room. There's a bunch of handouts going around, so make sure you get the handouts, and then a sign-in sheet. So if we've stopped the handouts, let's make sure we got those going around. I think there's like 5. What we'll do to start is just go around the room, name, introduce yourself, name, how long you've been a realtor, and then I guess if you've ever dealt with probate before. So start down here. I caught your eyes, so that's why I thought.
My name's Dominique, and I literally passed the exam like 2 weeks ago.
Awesome.
So,
all right. Cool. Brand new. All right. Welcome.
Thank you.
My name is Jennifer. I have heard of probate.
Okay.
I don't know my words.
Okay.
And I've been an agent for 4 years.
Okay. Whose phone is that? The one that can you push like a stop on it? Thank you. All right. So everyone got this page?
No.
Okay. We got one here.
Yeah, you got the
We got it. Okay. Yes, ma'am. Go ahead.
Alright, my name is Leslie Santos. I've been a realtor for 5 years and so. And I know about probate because it's very close. My mom's going through it and it's been a nightmare.
All right. Very good.
Luciano Garcia, I'm a realtor for the last 4 or 5 weeks.
Awesome. Brand new. All right. Very cool.
Thanks, I attended I take the test before last night because they closed the facility for the next 30 days.
Good. All right. Thank you. Yes, ma'am.
My name is Carmen Lopez, and I've been a realtor 8 months.
Okay. No probate?
No, but I know about probate.
Okay. Yes, sir.
I'm Matthew Lewis. I had my license for about 14 years now.
You're the veteran so far.
With, I'm familiar with it.
Okay. And you were here last time, so you got, yeah.
My name is Amaida Hernandez. I've been a realtor for 15 years, and I know probate because I took the course. I took a course and I got certified, but I haven't been able to close a probate deal yet.
Gotcha, okay.
So, and I've done a lot of stuff. I've knocked on doors. I've sent, postcards and stuff.
Sure.
But,
Okay.
you probably teach us more about how to get deals and.
Yeah, we'll talk a little bit about that at the end, yeah, absolutely, okay.
I'm Diana Ruiz. I've been in real estate for 2 years. I heard about probate, but I haven't dealt with any probate case.
Yeah, my name is Mercedes Bravo, and I took my test 4 weeks ago.
Oh my gosh, brand new agency here. Yeah, awesome.
My name is Carolina. I've been a realtor for 6 months, and no probate.
Okay, 6 months, all right.
My name is Celia Brizuela, and I've been a realtor for the last 28 years.
Wow.
She wins.
And I made a sale that was a probate. So I have some common knowledge of that,
Okay, great.
but not completely.
Okay, great. All right, so overall pretty brand spanking new agents. So awesome, very cool. I think you guys chose a great brokerage to work at. So welcome. Is there anything we're going to touch on a lot of different aspects, but so I know marketing to probate, that's something we'll touch on. Is there anything else, any specific questions you all maybe have, that you really, I'll try to make sure I'll touch on, answer, try to focus in on? We're just generally interested in probate. Yeah.
How to get deals? Because like I said,
We were gonna give you all our cards, so when they call you, you can send them our way.
Gotcha. All right. There we go. There we go. Okay. So marketing. Yes, ma'am.
Yes, I had a couple of friends of mine. They just made an offer on a probate. The deceased just died maybe a month or two ago, and the son of those deceased made a contract with them. But I understand it has to be to a process about 6 months. They cannot move immediately until the court
Okay.
finally.
We'll talk about that. Yeah.
Yeah.
Okay. Anything else? Okay. Perfect. So I guess probably the best place to start is I just want to identify a couple key definitions, explain a couple things that I think you all, need to know so that we can kind of move into the conversation. So probate, what is it in general? Well, it's basically someone has to have passed away in order for probate to occur. So unfortunately, it's somewhat sad, but there has to have been a death in order for probate to happen. And what we're doing with probate is, we're in your world, in the real estate world, someone owned a piece of property, okay? When they passed away, now that, I think everyone signed? Okay. All right, I'll send it back. After someone has passed away, they owned a piece of real estate, right? And so now we're going to open what's called a probate with the court, and there's going to be a judge involved, there's probably going to be an attorney involved, and at the end of the process, the judge is going to say who the new owner of the property is. So for you all, you find a piece of real estate that was owned by John Smith while he was alive. John Smith has died. Now it's owned by what's called the estate of John Smith. And before you can sell that property or do anything with it, it has to go through the probate process, and the court is going to say who the new owners are. Does that make sense? Okay. So, anyways, when you hear the word probate, unfortunately, it just means that someone's passed away, and we got to go through the court process so that a judge can say who the owners of the stuff is. Estate, so E-S-T-A-T-E, estate. I just mentioned when John was alive, he owned his house, he owned his boat, he owned his car, he owned money, whatever he had. And we refer to all of that stuff as John's stuff. When John passes away, we now refer to everything as his estate. So his house, his car, anything that he owned, we say the estate of John Smith, or whoever the person's name was. If he owed money to a hospital, to Visa, to whoever, that's also included as part of his estate. So anything that he owned, what we call assets, or anything that he owed money people to, we call his liabilities, we say the estate of.
But if, I'm sorry, if John has a will, they don't have to go through probate.
They do, but we'll talk about that.
Okay.
They do, but we'll talk about that.
I understand, is it possibly for the son of this lady that died to give, to rent the property before the court judgment?
Well, just hold on for a second with your questions about the specific, because I just want to explain some definitions right now.
They cannot close until the court.
Yeah, I'll answer that, but just let's get through some of the definitions before I get into specifics about that. So that's what an estate is. Probably the most important definition for you all, the most important thing for you all to know is what's called the personal representative. So there's the personal representative. Some states use what's called the executor. For example, New York uses the term executor, but in Florida we use the term personal representative. Just to make it easy, because I'm going to say personal representative a lot, I'm going to say PR for short for personal representative, because it's a lot easier to say. So
the person determined by the court to be representing the state.
So the personal representative is assigned by the court, okay? The judge is going to say who the PR is, and the PR is the person who signs the listing agreement. They're the person who signs the as-is contract. They're the person who has authority to actually sell the property. So whenever you all are potentially going through the probate process and you find a piece of property that has to be sold, you need to make sure that you're working with what's called the PR, okay? One very important thing to know about the PR is that the judge actually has to name this person. And we'll talk a little bit more about that here in a bit. But even if someone has, let's say, a will, right, which we'll talk about a will here in a second, and the will says who the PR is, that person does not become the PR until the judge signs a piece of paper saying that they're the PR. Yeah, yeah. So the biggest thing right now, just to kind of know, is that what I want you all to know up front before we kind of dive into everything is that the PR, that's the person that you all will be working with. If you're working with the seller, the seller is really the PR. If you're representing a buyer, you're buying from the PR. The PR is the person who gets to sign everything. Yeah? All right. Last, will and testament, so what we call just a will. A will is a piece of paper that is signed while somebody is alive, and it says who's going to get what of your stuff after you die, right? So I might have a will, and I say, I want my wife to get this, I want my brother to get this, whatever it is. And that's basically, we're going to take that after I pass away. The attorney is going to take that will, give it to the judge, and the judge is going to say whether or not it's valid or not. Yeah. And so one big thing is, since you brought it up, having a will does not avoid probate. So unfortunately, if you have a will, or if someone has a will, and the will may say, I leave the house to Justin, okay? But I can't take that. If I take that will, and let's say the property, 123 Main Street, and my dad leaves me the property, I can't go to the county, to the property appraiser, to tax collector, what have you, and say, look, my dad died, here's the will, he left me, 123 Main Street. The county appraiser, the property appraiser is going to say, unfortunately, you have to go through the probate process in order to get the property in your name.
And you must appoint an attorney also.
Generally, yes, the court will require you to use an attorney if you're doing a probate process, yeah. Okay, so that's what a last will and testament is. Any questions? Those are probably the main things, main definitions we need to know. Any just questions about the definitions? All right.
What about if you have a trust? Does it also go through the
We'll talk about that. But any questions on those specific definitions? If not, so best place to start is, well, let's ask our new agent here, brand new agent. So someone says, hey, I've got a listing, or I want to sell this property. What would be one of the first things you do? They say, hey, my mom owns 123 Main Street. What do you do?
Great. I would probably ask them when they need to sell one.
Okay. So you would probably, one of the first things you would do is you'd go and you want to find if they're actually the owner, right? So you want to make sure if someone calls you and says, hey Justin, my mom has this property, she wants to sell the property, you probably go to the county appraiser website. Sorry to put you on the spot, but thank you. You're a good sport. You're a good sport.
Cool.
Yeah, you wanna make sure that they are in fact the owner, right? So you're probably gonna go to the county appraiser website to see if they're in fact the owner. So that's one of the easiest ways to know whether or not probate is necessary in a case that you're working on. Okay? So if somebody calls you and says, hey, this lady just passed away, right? Someone just died, then chances are probate's going to be necessary. But if they don't tell you that, if they don't tell you that somebody died, when you look up the property and you go to the property appraiser's website, you can tell from that whether or not probate's necessary. So you guys should have a handout of 3 different property appraiser. I don't see anybody having. They were being passed around. There were sheets with 3. You didn't pass. Did you pass? It's yours? Yep. So they got stuck back there. Yep. So we need to pass those out. Okay. So these that are coming around now, they might be stapled backwards, but the one you need to look for is the one that shows the owner as Maria Pichardo. It's property address 11309 Southwest 200th Street. Did everybody see that one? All right, so Maria Pichardo, and then after that we have EST of. Take a guess what that means? Estate of. So whenever you see that EST of after somebody's name, that means that that person has died. Okay? And 99.9% of the time when you see that, it means that probate's necessary. It means that before that property can be sold, it has to go through the probate process. So this is probably the most common thing that you all will see when you're looking at a property appraiser's website and you see that EST of, again, 99.9% of the time, probate is likely necessary. Now, it might be that the probate is already opened, and I always get asked, how can we find out? Really the only way is you have to go to the clerk's website, the clerk of court website, and search by that person's name, and you'd be able to find out. But what I really just want you all to know that is if you see that EST of, again, probate's probably necessary, so before you could go and sell that property or do anything with it, you've got to complete the probate process. Any questions on that one?
And how long does it take?
So
I'll answer that at the end. Yeah, we'll get there.
with or without a will?
Will doesn't matter. Having a will does not avoid probate.
Yeah.
Having a will does not avoid probate. Easy? Okay. So again, this is probably the most common one that you'll see. Let's go to the next one. Jesus Silva and Maida Silva. Property address 1821 Northwest 33rd Street. So if you see this, this is pretty common. This is pretty common here in Florida, where you're going to have 2 owners on a piece of property, right? So father, son, father, daughter, or investors, or brother, sister, what have you. A lot of times you're going to have 2 people on a piece of property. In this case, you can see Jesus Silva, and then you see the EST of after the name, right? So what that means is Jesus has passed away, right? So remember we said Jesus, or the EST of means estate of. So what happened in this case is Maida was the daughter of Jesus. Jesus passed away. Jesus was not married, his wife had passed away. Maida didn't have any other siblings, she was the only child. So Maida goes, she gets a realtor, they list the property, it took about 4 or 5 months, they get a buyer, they go to closing, and the title company says you have to do a probate for Jesus before the property can be sold. So she thought that, well, I'm already on title with my dad. There's no other siblings. I'm the only one who's going to get this property. So the realtor thought that they were going to be able to sell the property. But because they didn't do a probate for Jesus, they weren't able to sell it. So the way they own this property, and so I don't want to get too much into title, but the way they own this property is a way that's called tenants in common, which basically just means that Jesus owned 50% of the property and Maida owned 50% of the property. So when Jesus died, his 50% did not automatically go to Maida, it just stopped with him, which is why they had to do a probate. I'm going to talk about some other ways that they could have owned the property to have avoided probate, but the way they owned this specific property was by what's called tenants in common, meaning dad owned 50%, daughter owned 50%, and when either of them died, they had to do a probate for the person who died. It's a way, yeah. How you hold title is definitely a way that affects it. So this example, this Jesus Maida example, again, pretty common here. So if you see this, if you've got, and this realtor, kind of made a mistake by not asking, her title company, her attorney, whoever, or even, investigating a little bit more. She just saw, oh, Maida, my client is already on title, I'm just going to go sell this property. So she went and marketed the property, wasted a bunch of time, and obviously the client was, a little mad at her at the end of it. So if you see this, again, if you see that EST of, or again, if you know that someone's passed away who's on title, do a little bit of digging before you just automatically list the property and go try to sell it. Okay. Now, how could they have avoided the probate process? So, tenants in common, like I said, that's just the default way of owning a piece of property. If you own it that way, when one of the person passes away, you're going to have to do a probate for the person who died. They could have owned the property by what's called joint tenants with right of survivorship. So what that basically means is when one of the owner dies, his or her portion, his or her 50% automatically goes to the person who's still alive, and they don't have to do a probate. So, and that's language in the deed itself. So it would let's just use that example. If the deed had said Jesus Silva, a single man, and Maida Silva, a single woman, own this property as joint tenants with right of survivorship, then when Jesus died, his 50% would have automatically gone to Maida, and she would not have had to have done a probate for Jesus. And they would have avoided the entire process.
What document should we ask from the client to see that?
That would be on the deed. That would be on the deed, on the title. Yeah.
When it's purchased.
Yeah. Or you can do it later. Yeah, you can add that at any point, really. Generally, anytime. So if you have that language on the deed, then you would avoid the probate process. Another type of deed that you can do is what's called, there's two types. There's one that's called a life estate deed and an enhanced life estate deed. Okay? So what those two types of deeds are, so life estate, what a just general life estate deed is, let's say I own a piece of property. I own 123 Main Street, and I want my brother to get the property after I die. So I don't want him to have to go through the probate process. I can add him on the deed, on title, where it says, I, Justin Stivers, own the property. Essentially, this is not the correct language, but essentially, when I die, I want my brother, I don't have a brother, but I want my brother, Bill, to get the property, okay? When I die, he becomes the owner of the property, and he doesn't have to do a probate. However, let's say that in a year, 2 years, I really hate my brother, or he marries someone I just really dislike, and I don't want him to get the property. Well, if I put him on the title with the life estate deed, I can't change the title, I can't sell the property unless I have his permission, which becomes kind of problematic because, again, he might not say, okay, yeah, if we don't like each other, he's probably going to say, no, well, let's just sell it and we'll split the proceeds, right? So you have to be careful. So what Florida has is what's called an enhanced life estate deed. It also has another term called Lady Bird deed. That's what its kind of like nickname is, but it's really, the legal name is enhanced life estate deed. And with that type of deed, I can do the exact same thing. I can say, I, Justin Stivers, leave the property to my brother when I pass away. but I have other language in there that says I can take him off of title, I still own the property, I don't need his permission if I want to sell it, or if I want to take him off, I can do it without his permission. So it's a really good tool that can avoid probate and leave the property to someone, and still gives you the flexibility to change the deed later down the road if you want to. I know it's like a lot of information, so.
And who does the Lady Bird deed? You have to see a person like yourself, or just a regular attorney?
Well, I would say a regular attorney, but I mean, an attorney who knows to do these types of things. Probably, you know, a real estate attorney. We do them. A real estate attorney, maybe a title company that is owned by an attorney. I don't know if general title companies do them or not, but yeah.
Can we list the property of the deceased person that needs to be to the process?
We'll get there. Wait for me. We'll get there. Yeah, we'll get there. Yeah. Any other questions on that?
So basically, the main difference between the life estate deed and the enhanced one is that the enhanced can be changed throughout the life of the ownership.
Correct.
And the other one is set.
Great. Yep. Yep. Perfect. Okay. So changing the deed is a very easy way to avoid whoever you're leaving this property to, an easy way to avoid the probate process. Another way is by doing what's called a trust. Okay. So if we look at the last handout that you guys have on these, property address 13926 Southwest 161st Court. The owner, Karen S. Rodman. Okay, so a trust is sort of like a will. It's similar to a will. A trust says who's going to get your stuff after you pass away. Same idea. It's going to say, if I want to leave the property to so-and-so, if I want someone to get X amount of dollars, whatever the case may be, it's the same idea. Except that, like I said earlier, a will does not avoid probate. A trust, if done properly, can avoid probate. So on this one we've got here Karen S. Rodman, and after it we have TRS. So that TRS stands for trust. So one way that you can, your clients or yourselves or whoever can avoid the probate process is two steps. First you create the trust itself, right? So we've got a legal document that is actually, it's called the trust. Let's just say the Justin Stivers Trust, dated, March 16th, 2020. But then I actually have to change the deed. So I have to, let's say I own individually 123 Main Street, Justin Stivers, 123 Main Street. I create my trust. Now I have to deed the property from myself individually and make the trust the owner of the property. So I, Justin Stivers, was the owner of the property. I do a new deed, and now the Justin Stivers Trust, dated March 16, 2020, is the owner of the property.
Is the trust similar to a corporation?
No.
You don't need to create an LLC and all that to be able to work for it.
So very important, this is where a lot of people, when they do a trust, they mess up, is they do the trust document itself, and they just have the trust. But they don't actually change the title to the property. And so they create the trust, so the Justin Trust is set up, but the property is still owned by Justin individually. And if that happens, then the trust is pretty much worthless, and you would still have to go through probate to get the property.
So same thing
So
happens.
you have to change your name to the trust. On the title.
Yeah, you have to change title. You have to
The owner is the
change.
trust.
You have to change title from you who own it individually and make the trust the owner of the property.
In the trust, you can add any person you want.
Yes.
And that person is, if something happened to you, that person owns whatever you have in the trust.
Correct.
With no probate.
Correct.
And how about if you decide to sell, let's say that you have 2-3 people in the trust. If they make the decision to sell something that is actually yours, but it's in the trust, they have the right to do that?
No, they only become the owner once you die. Once the owner of the trust dies.
And if you want to remove.
Hold on, let me let you do you have questions?
Yes, I know if I understood well, you have, that is the revocable living trust, what you are talking about. When the person dies, they inherit immediately all the properties and they don't have to pay the taxes. Is that correct?
No, generally that's not correct.
No,
There's still likely going to be some sort of tax that they have to
Is
pay.
that the same thing that the irrevocable living trust?
It's not really the same. It's not really the same. It's not the same question. Yes, we're talking about a trust. Taxes are separate. I mean, there would be taxes on them.
But they don't have taxes for inherit. The problem.
Is there a tax on inheritance of a house?
There's an inheritance tax. There's an inheritance tax of a little over $11 million.
No matter what.
There's an estate inheritance tax that someone inheriting something would have to pay if what they're inheriting is over 11 million. But that's a little bit outside the scope of kind of what we're talking about right now. Yeah. Do you have a question? Okay. No, good. Okay. So main thing that I kind of want you all to get from this is that how your clients or how whoever, if you want to avoid the probate when it comes to real estate. So we're really only talking about real estate here. It's by changing how the property is owned on the deed itself, or by doing something like a trust. Again, we're still changing how the property is owned, but we have to set up the trust itself.
In my opinion, to avoid that, the easiest way, instead of going into a trust and someone files the wrong paperwork, it would be better to joint tenants with rights of survivorship would be the easiest way.
It depends, sure. But again, let's say that you want to put your brother on the property. Once you put him on as joint tenants with right of survivorship, you can't ever change that. So I mean, again, I was going to say your spouse, but so just one thing, husband and wife would avoid probate. They have what's called tenants in the entirety, which basically just means husband and wife own the property. When husband dies, wife automatically gets it. When wife dies, husband automatically gets it, and they don't have to do the probate process. And that's not language really. You don't have to put joint tenants with right of survivorship. Usually the deed itself is just going to say, so and so a married couple, and that's it.
Yeah, if it's on there.
If it's on it, right? Yeah.
So what's the benefit of having the trust if you can do the deed with joint tenants or right of survivorship? You said that you can ever change the deed again. You can change it back, right?
It depends. So this is I'll answer this. The difference why you might do a trust. So the reason why you might do a trust, trust may not be necessary in every situation. If you just have one piece of property and you want to leave it to your only child, you probably don't need to do a trust. Trusts come into play maybe when you have multiple properties, maybe when you own a company, maybe if you have minor children. So if you've got kids that are under the age of 18, we always do them for our clients that are when they have kids under the age of 18, because you can put language in there that if mom and dad died, who's going to take care of those children? Because a lot of times what happens, if parents die and you've got kids who are 7 and 8 year old, a court case is going to have to be opened, and now the court's going to decide who becomes the legal guardian of the children. And then you've got fighting between in-laws or siblings or whatever. So trusts are good for a variety of reasons, but it might not be, if it's just one piece of property and you have one child that you want to leave the property, yeah, you could probably do a deed. The deed, like what he was saying is, you could do the joint tenants with right of survivorship, but again, if you put them on that deed as joint tenants with right of survivorship, you can't take them off unless they want to be taken off of. So you might not want to give them 50% ownership. You can do what's called the ladybird deed, which I was talking about, where you leave it to them when you pass away, and they don't have any ownership interest while you're alive, but when you pass away, they get it, and then you can change it. So it really depends. There's no one size fit. It depends. It depends. There's no one size fit all. It really depends on what the person's specific situation.
And does that work? Like, let's say you have a kid that's 18 years old, so you can put him on the deed. But you have a younger kid, and you say
no, you can't put them on the deed.
You can't.
You can't put them on.
So you would have to do the enhanced.
There would be You
Well,
can't
do
put them on
life
the deed.
estate, life estate,
can't
put
put 'em
them
on
in
the deed.
order, who gets it in order.
It has to be an adult to be in the deed, right?
No, I understand, but if you have somebody, you have a, let's say you have a son that is 18 years old, and you have a younger kid, you can put the 18-year-old, but you cannot put the minor.
Yes, correct.
But how you make sure is that if something happens to you if you die, that, you know, that they share the.
Right. So good question. I can't answer every single, because we have countless, you know, situations. So that's why I say I can't just say always do a deed, always do the enhanced life estate deed, always do a trust. If you have a minor child and you want them to get a piece of the property, then the trust might make sense.
Okay.
Because if you put your son, if you have a son who's 18, you have a daughter who's 15, and you put the son on the deed, the son's going to get that property 100%, and your daughter's not going to get anything. So you probably want to do a trust or some sort of thing.
Okay.
So I'm going to pause it right there, and last question on trust, because I know I always get a ton, and I want to get. Can a trust? Yeah, you can always change a trust until you pass away. Then it becomes. Yeah. I get asked. So. All right. So those are probably that kind of first section is how to identify when a property is going to go through probate, how to avoid it. Right. All right. So the next quick section, which I want to rush through because we're running up on time a little bit, is let's say we've determined that probate's necessary. And again, I say we, but you're probably going to speak with your attorney, speak with your team or whatever to get to know 100%. But let's say that okay, great, we know that probate's going to be necessary. Like I said in the very beginning, 30 minutes ago, you need to make sure that you're working with the PR, with the personal representative, because they're the ones who get to sell the property. So you need to, let's say that there's no attorney involved yet. All right, you just get a call and someone says, hey, my mom passed away, I want to sell her property. Great, so you go to meet with this prospective client. There's a couple questions that I generally recommend that you all ask just to make sure that you're speaking with someone who we think will become the PR. First of all, ask them if they have a will, a last will and testament. So ask them if they have a will, right? And the reason is, we said earlier a will doesn't avoid, if they have a trust, we're going to know because it's going to show up on the deed. If they have a will, let's say that you're speaking with the daughter. There's only one daughter. And she says, no, my dad passed away. I took care of him when he was sick. He says I get the property. I don't have any other siblings. And we go ask her and she says, oh yeah, my dad has a will. And the will says, I leave the property to my girlfriend. Which happens, right? Which happens. Or to a church or to something else. And so the daughter is not going to get that property. Well, we know at that point that you're kind of wasting your time speaking with her because she's not the one who's going to get to hire you. She's not the one who's going to get to sell the property. So that's why we want to ask if there was a will. Now, your job as the realtor is not to determine whether or not is a valid will or not. That's my job. But you can at least, just see if there was a will. If they say that there was, we want to ask if there was a copy of it. Did they have a copy of it, or can they get a copy of it? The reason is because there's no database that I can go to find out if a person had a will. So I could do a will right now. The requirements are generally pretty limited. It needs to be witnessed. It doesn't have to be notarized. It's a good idea to have it notarized, but it doesn't have to be. So I could do a will right now. Two of you all witness it. I put it over here. When I die, nobody knows that I had a will. So I've had a client recently, ask me. They say, I think my mom had a will, but I can't find a copy of it. There's nothing I can do. So again, you just want, if they say there was a will, ask them if they can get a copy of it.
The will is not recorded?
Nope, not recorded.
So if you want to record it, could you?
Not really, no.
So it's basically just a piece of paper two people sign and then.
And it doesn't have to be recorded in the court?
No. Once we start the probate, if we have a copy of it, we give it to the court. Because the court needs a copy of it to say whether it's valid. But people don't record it. It's a very outdated, it's an outdated system. Because there's a variety of reasons. But chances are you do a will, let's say when you're 35, right? Maybe that's around the time you start having kids, so you had, or whatever. You have, and then you get mad at one, or your situation changes when you're 65, 75, whatever. You acquired more stuff, you want to change it. It would be a pain and a half if you've got one recorded with the court, which they probably wouldn't even accept it to begin with. So they're usually, I guess in my office, We keep electronic copies, we give the originals back to the client. I say, you know, keep this in some place safe. I say don't put it in a safety deposit box because when you die, it makes it really hard for anybody to get access to it. So put it in, you know, a fireproof safe, something like that. But yeah, so they're not recorded. That's why you want to ask them if they have a copy of it. The next question is,
Can I ask you quickly, how do you determine if the will is
Legit.
acceptable? Yeah.
Legit.
How the judge or you or whoever says.
long story. That's too long, and you guys don't need to know that. You don't need to know that. Because I have to go to the court and show it to the judge and argue it, and just generally speaking, there's so many variables to it. I mean, I've fought wills where mom had Alzheimer's when she signed the will, and so we fought her on that. So outside the scope of this course, but okay. So running, I want to get through some other stuff. So we asked if there was a will. We asked if we had a copy of it, and then we want to ask, what was your relationship to the person who passed away? Right? So was this your mom? Was this your brother? Was this your uncle, aunt? Who was this who died? And the reason is, if a person does not have a will and they don't have a trust when they pass away here in Florida, the law basically says who gets what. So first it goes to your spouse, then it goes to your children, then it goes to your parents, then it goes to your brothers. So if there's no will and you're speaking with a cousin, chances are you got to go through a lot of people before you get to, Tio or Tia who's saying that I'm going to get the property, right? So I always ask, what was your relationship? If it's a son, daughter, chances are they're more likely that they're going to receive something, but if the further out you get, distant cousins, uncles, aunts even, it makes it a little bit more difficult. So if a person does not have a will, like I said, it's usually parents to children, spouse to children to parents to brothers and sisters. So ask what your relationship was. Questions on that? Okay. Once we figure, and I say we, but generally, once I figure out, okay, great, I think this person is going to be the personal representative. Now they can hire me, they can hire their attorney, whoever. We go to court, and I get them appointed as personal representative. Once I get that piece of paper from the judge saying that they're personal representative, now you all are free to market and to list that property. Okay? So before then, right? So let's say you've got a client and they say, look, here's the will. My dad says I'm going to be the personal representative. My dad left me the property. Looks good. Okay, they come to my office. They hire me. From the date that we get hired and file everything with the court, on average, it takes about 30 days to get the court to approve them as personal representative. On average. Again, with this stuff going on right now, all of our hearings today got canceled, and the court, I think, just closed today until the end of the month. So it could be longer. But on average, it takes about 30 days to get them appointed as personal representative. But let's say somebody comes to you on January 1st, and they say they want to sell this property, but they're not yet listed, they're not yet appointed by the court. You probably still want to get them signed up because you don't want to say, come back to me in 30 days once you're appointed as the personal representative, because they're going to go to, I think there's like a brokerage literally like downstairs across the street, right? So they're going to go over there and say, so what I normally recommend is when you have that listing agreement, you have them sign it as the proposed personal representative. They're not yet the personal representative. They will become the personal representative, but we just kind of get them to get locked in a little bit and have them sign as the proposed personal representative. Then, after we get them appointed by the court, now you can update the listing agreement and say John Smith as the personal representative. But until we get that from the court, do not list the property, do not market the property, don't do anything with it until we get them actually named as the PR.
So don't put it in the
So they have to.
Don't put it on the MLS.
So they have to put their name and then next to it propose PR?
Yes.
Something like that?
Yep. Yeah. Okay. All right, so now, once they are the PR, now they can sign the listing agreement as the personal representative. Once you get a contract entered, they can sign it again as the personal representative, and you are free to market, put it on the MLS, and do all of that. So, length of time. How long does the probate process take? Well, like I said a couple minutes ago, from the date that we get hired and we file the case with the court, it takes about 30 days for them to get appointed as the PR. Then there's two different timelines, and it really depends on when the person died and when we open the probate case. So if the person died more than 2 years ago, so let's say we're opening the case in 2020, but the person died in 2017, right? So more than 2 years ago. 30 days to get the personal representative appointed, and then during month 2, you guys can sell the property. So if the person died more than 2 years ago, it's probably, I would say it's probably about a 3-month process. About 3 months, more or less. Could be a little bit longer, but about 3 months if the person died more than 2 years ago. If the person died more recently, so again, they died in 2019 and we opened the case in 2020. 30 days to get the personal representative appointed. Then we have to wait 90 days after that point. So we gotta wait month 2, we gotta wait month 3, we gotta wait month 4. Around month 5 or month 6, you can sell the property. I'll tell you the reason why we're waiting. But basically, if the person died more recently, so within 2 years, the probate process is probably gonna take about 6, maybe 7 months. 6 or 7 months is kind of on average. The reason we're waiting the 90 days, so the reason after, we have a 90-day period after the PR has been appointed, we have to wait 90 days because that's a Florida law where if the person who died owed money to anybody, owed money to Visa, to Palmetto Hospital, the Baptist Hospital, to whatever, they have a 90-day window when they have to do what's called filing a claim. They come to me, the attorney, and say, hey, John died, he owed us $20,000, where's our money, sort of thing. We have to wait that 90-day period before we can sell any property or transfer any property. So if it's, again, person died within 3 months, or within more than 2 years, it's about a 3-month process. If they died more recently, I'd say it's about a 6 to 7 month process.
So if it's, can you please repeat that again? If they die recently, is how long?
6 to 7 months.
6 to 7 months. And if they died 2 years ago?
3 to 4 months.
If they owe money to,
So if they owe money,
they don't have any money to buy.
if they have no, so let's say someone dies and they don't have any money, right? So someone dies and they just don't have anything. Well, the creditors aren't going to get paid. The sibling, the heirs, whoever's receiving anything, does not have to come out of pocket to pay those creditors. So let's say mom died and mom owed $5,000 to Macy's, right? And so now Macy's is saying, hey, where's our $5,000? Mom and dad, the kids don't have to come out of pocket to pay that. The only way Macy's is getting paid is if mom had money in a bank account and now they might take that money. If the only thing that mom had was her property, and it was her homestead property. So what homestead is, you guys probably all know, but basically homestead is your primary residence. It's your main house. It's where you live. You get a tax exemption on it. If the only thing that you own is your homestead property, it's exempt from creditors. So if Macy's says they're owed $5,000, Baptist Hospital says they're owed $100,000, and mom only had her homestead property, they're not getting a dime. Now, if mom had a second house, an investment property, they could force the sale of that to get repaid if they wanted to. But homestead property is completely exempt. The only creditors who can go after homestead, unpaid mortgage, homeowners association can foreclose, the IRS, unpaid property taxes, that sort of thing, they can all go after that. All right, how are we on time? We've got a couple more minutes. So that's kind of the length, that's kind of length of time. Cost, because I always get asked about cost. Most average probates, I would say on the low end are around $3,500 to $4,000. On the higher end, probably $8,000, $9,000, depending on it. That's more or less, kind of a range for probably most of the probates that you all will come across.
So 3,500 to what, to 8,000?
8,000, 9,000, somewhere around there. Yeah, it depends.
That's the cost.
More or less.
How much? The entire process.
Yeah.
3,500 to more or less 9, no more than 9.
Yeah.
9,000.
It depends. I mean,
It depends on the activity.
It depends on the activity. All right. So if you, I have cases right now where again, we have the case I kind of mentioned where grandmother did a will in 1995. She did a second will in 2008. my client who was left the property in 1995 was fine, but the will that was done, 13 years later was when mom had Alzheimer's, when grandmother had Alzheimer's, and she came from Cuba, so we had to get her hospital records from Cuba, have testimony from doctors in Cuba, all this type of stuff. That was a lot more expensive than the average. But if it's just kind of standard, we just need to transfer property. So that's why I'm just giving you a range, but it can vary. I mean, if you've got a multi-million-dollar estate, fees can be $50,000, $60,000, $70,000. So it just kind of depends on the case. All right, a couple kind of marketing marketing ideas. So probably most of you all will not be 100% just probate realtor, right? Like you're gonna have to find your average normal deals or whatnot. How you can find probate listings, honestly, referrals are probably gonna be your best source. So probate, chances are I would be better, or a probate attorney would be a better referral source for you all than you for them. Just because every probate that we deal with has a piece of property. Most of them have a piece of property. So, I work with a lot of realtors. Most other probate attorneys work with a lot of other realtors that they need to refer out because the property needs to get sold. So if you find a way to reach out to other probate attorneys, network with them, build relationships with them, they can be pretty good referral sources for you. You can, that's not the virus. You can buy lists. So you could. There are list services. I don't recommend any because I don't really know them. But you can buy the name of the personal representative, the name of the attorney handling the case, get their names, their addresses, their contact information, and reach out to them. It's also public record, so you can search, probate cases online. You can go to the courthouse and find that information. Again, public record. I would probably, if you were going to do something like that, I would probably reach out to the personal representative and not the attorney. I think you have a better opportunity reaching out directly to the personal representative. When you approach them, your strategy is probably not, hey, we've got cash buyers who can help you sell this property quickly. Because mom just died, she probably doesn't, care that you can sell the property really quickly. I mean, she does care, but that's not going to draw her in and be like, okay, great, let's sell the property. So you want to come with a little bit more compassion, a little bit more empathy. I think, a lot of times people, like for example, all these two cases, Maria Pichardo and Maida, they didn't even know that they needed to do the probate process. So if you come to them and you say, look, you may or may not know this, but you have to go through probate. I'm a probate expert. I've got companies that can come help you out, help you clean the property from your house. I've got a team of probate attorneys that I can recommend to you. Whatever it is, very sorry for your loss, like whatever. Have like a different strategy than just, we can help you sell this quickly, sort of thing. Those are probably the best ways. I don't know if that answers your original question. There's not an easy way to. There's no secret way to market for probate listings. In all honesty, it is just kind of referral based. A lot of it is. Again, you can search the property appraiser's website. If you in the owner's box on the homepage, if you type in a state of, you'll get a list of properties that are owned by estates, and that's an easy list that you could start marketing to, doing mailers to, and that door knocking. That's what. All right. Hey, in the back, can you hit stop on that if it's? Yeah. Thank you.